Welcome back to the DoctorLady Podcast. In part 2 of my conversation with real estate lawyer Sim Jimenez, we continue unpacking how to approach contracts with confidence and ensure you don't give up control over what matters most to you. Sim offers practical advice, and I share more lessons from my own experiences with unethical contractors to help you avoid similar mistakes. If you've ever struggled with understanding contracts or trusting the process, this episode is full of valuable insights you won't want to miss.
Essentially what they did is they took advantage of your lack of expertise in this. And you're also kind of thinking, well, the way they're explaining it is, no one's ever going to explain something in terms of worst case scenario.
I know an attorney told me once, and it was just really mind-blowing to me, because I was talking about fairness, and he said, the legal system is not about fairness. It's about legality. Is this legal or not? So take out the word fair.
Yes.
Because this isn't about that. And that blew my mind, because I'm like, this isn't fair.
It's about the scales of justice.
Yes.
Yeah.
Yeah. And so I think that, I don't think I'm alone in that. I think a lot of people think that, like, the legal system, it's like, okay, it's trying to make it fair.
Yeah. That's a really difficult and true statement, what he said to you. Difficult in the sense that I can't tell you how often when I'm asked a question, but it's not fair is the art. Yeah. And the humanity in me is like, for example, in the circumstance you shared, that's horrifically unfair.
Yeah.
It's entirely opportunistic.
Yeah.
And that hurts my heart as a human. Mm-hmm. As a lawyer, the agreement allowed for it.
Yeah.
And it's unfair, and you would hope that a very astute judge and some very astute attorneys can do their cool litigation stuff to get to that outcome. But I think there's a lot of truth to what that attorney told you. So often, like my own family is probably my biggest teacher of this, is I would get these calls from years ago from my father, from my brother, from my mother, in the context of the businesses that they were working on, or some deal that had gone south. And it was like, but that's not fair. Right. That's not fair. They said this. They said that. And it would be like, okay, but what does your agreement say? As the lawyer, that's what what does your agreement say?
Yeah.
And if you look at me blankly and say, yeah, it says that, but.
Right. Doesn't matter.
Here's my question. Here's my advice on the but. If you talked about it after the fact and there was some new agreement reached, because that happens all the time in the case of construction. Oh, we said we were going to spend X amount on this. Then the client looks at this and says, I'd like to upgrade. Okay, well, was that put in writing? Did you say who was going to pay for what? Did we amend the agreement? Because if you had a conversation after the fact, my friend, that does not hold a lot of value in the law.
Yeah.
What holds value is your contract. Your contract can be amended at any time.
Yeah.
It requires somebody to draft an amendment.
Right.
It doesn't have to be that sophisticated. Yeah. You can probably pull a form off the internet. Is it, again, going to cover every potential hypothetical? No, but it will at least now create a binding agreement that says, hey, the original agreement said X. We have, as two parties, mutually agreed that now it's going to be Y. And so now you sign that.
Right.
And there might still be a technicality in that. Yes, again, depending on how sophisticated the two parties are, how much money they want to spend on legal fees, how much time is involved in delivering whatever, the service is. You might say, okay, that's good enough. Yeah. I've seen amendments on paper, like on chicken scratch on paper, that like it's handwritten and the two sides sign it and date it and cool.
Yeah.
Yeah. And it's notarized sometimes.
Wow.
Yeah. So that's a big thing. Put it in writing.
Put it in writing. Exactly. I mean, I know I have a leading up to a question, but in the terms, in what happened with my situation, I don't think that this group was a good group. I don't think they were upstanding in how they did things had I been more careful about making sure the things that they were saying were in writing. I think a lot could have been avoided. You can't just hope that people are going to be good people. And in terms of like the budget for our project, me being very straightforward and saying, how much is this going to be? Because that will be all that we have. And then basing our loan and our budget on that, being very clear and transparent, thinking that that was a helpful thing. It turns out that my transparency harmed me because they knew that I didn't have more money to end up fighting them. And when they said, we need to do a cost plus agreement because that's the only way we can get it through the city, and this is what we do all the time. And then my words were, okay, but the thing is you know that the only money we have is the money we budgeted, right? Yeah, we know. We'll work within that. Nothing was documented on that, which is what ended up biting us at the end. So my question then leading up, is there ever a time that a cost plus agreement makes sense to, and especially maybe a small business, and maybe you can explain what a cost plus agreement is, and then just say like in what, why someone would agree to it? Because clearly having that discussion of saying, okay, I can see, but you need to stop at a certain point because this is all the money we have. In our situation, what they did was after the fact of going over, came back and said, well, we went over and you had a cost plus agreement, so that's what we did, without any change order signed. So my question then specifically is going over what a cost plus agreement is, and that was foreign to me. I didn't really understand that. And when would it ever make sense?
So, okay, what I think you mean is that you signed an agreement. First, you had a contract agreement as a client with a contractor that they're going to provide XYZ services and they're going to get paid a set amount of money. And then afterwards, they came to you and said, we'd like you to sign this agreement that we're calling a cost plus agreement, which is saying that you agree as client that even though we have this other agreement that says you're going to pay Y amount of money, this agreement says if the cost goes above, then you will also pay that. Is that correct?
They said, they actually didn't explain that, and it just said
but
cost
is that,
plus.
Yeah,
but that is,
that is what the content of the agreement
they gave
said.
A projected, my first contract was this is what our bid is, this is what we think it'll cost.
Correct.
And then they did it, they came back when they were going through to the city, and they said, well, because it's so far out, there may be some changes.
Some pluses.
Maybe some changes in costs of like the flooring between the months, between when it's approved and now. So we need to give room for that.
And there was no ceiling to that.
There was no ceiling to that.
Yeah. So that would have been a wonderful example of like, hey, so I agreed to pay this. And now you're asking me to sign something that says that costs go up and we can't really accurately predict those. And you're wanting to be a fair, wonderful client and say, well, okay, I understand that construction is changing. We all happen to know that post-pandemic construction costs went through the roof and things changed. So sure. And so if I was representing you in that agreement, I would say, okay, I don't know enough as an expert in my field to tell you what is a reasonable number, but I need you to tell me what is comfortable for you, that we put some kind of ceiling into this agreement. Because essentially what they did is they took advantage of your lack of expertise in this. And you're also kind of thinking, well, the way they're explaining it is, I mean, no one's ever going to explain something in terms of worst case scenario. They're like, no, our intention is, and sometimes I don't think this is the case for your particular contractor, but sometimes the intention really is genuinely like, oh yes, we really just think there might be a 10% increase in lumber. Okay. And then you leave that open-ended because you're sophisticated enough to know that maybe it's 12.
Mm-hmm.
And then in reality, what happens is something goes totally sideways.
Mm-hmm.
There's an embargo, who knows, something way beyond any of our control. And so then now you're in a situation where you're going up, 20, 30, 40, 50, 80% from your original contract value.
Yeah.
So when is it a good idea to do that? I mean, again, I don't think there's a clear do it here and don't do it here.
Mm-hmm.
But going back to my premise of, what your maximum output is. And you may very well say, so for example, a sophisticated client such as mine might say, we're not willing to take on the risk of more than 10%.
Yeah.
And by the way, if we pay this 10%, you need to provide proof. And this is what the proof is going to look like.
Yeah.
And this is how many days you have to deliver it to us.
Yeah.
And if you fail to do that, then we are not going to do that. And I would always require my clients' written consent.
Mm-hmm.
So when you see things, it says, and my consent is required, put in the word written. Mm-hmm. Anybody hearing this, put in the word written.
Yeah.
Because, we had a conversation.
Yeah.
You never want to take an agreement in writing, and think that you can dilute it or you can alter it orally. There are circumstances which, if I think back to evidence in law school 20 years ago, where oral evidence is admissible and yada, yada, yada. But I think two things come to mind in saying that. One, put it in writing. Mm-hmm. If you're providing consent, always ask for that consent to be written. Okay, so in terms of your original question of what's a cost plus agreement, it's an amendment. What you're talking about is an amendment to your original contract, where your original contract said, we will pay this. And it sounds like your amended contract said, we will pay this plus whatever else comes in.
Plus
and unfortunately,
50% more.
Plus 50% more of the contract value.
Yeah.
That's asinine.
Yeah.
Right?
Yeah.
I mean, you don't need me to tell you that. That's asinine.
Yeah. I think that comes down to like some of the pearls that you've said so far that I think about pain points for me that could have been avoided is just taking some time. And this is a hard thing, I think, for all of us in this world, for women who generally carry a lot of the mental load in all the things that we do and want to delegate off. But taking the time, as you put it, of saying, what is it that I'm concerned about? What is it that I want?
Yeah.
What am I seeking?
Right.
And is what I'm reading in front of me, is this contract addressing all of those points?
Right.
That is something I've never heard before, and I think is so helpful because it's before you even get into all these legalese words that can be like, this is a different language.
Right.
Right? But thinking first, what is it
that I want? Right.
I love that. And then stopping with those words and saying, what does that mean?
Right.
What does that entail? That is so important. And then everything in writing. Everybody, you know what? People say that. You hear that a lot, but I think you think, okay, this is in writing because it's a contract. Well, what isn't in here that needs to be in writing?
Yeah. And so when I say in writing, I mean, like, we can really go down a couple of avenues here. One, I want to clarify, a contract, whether it's the original agreement or an amendment to that agreement or the 18th amendment to that agreement, that happens, is something signed by both parties, dated, sometimes notarized, and that's an agreement in writing. Sending an email, by definition, cannot be an agreement in writing because it is one party documenting some data. As you know, and I think we all are aware that we have seen things in emails that are not remotely accurate. So when we say in writing, I think there's this misperception I have seen where someone is coming to me and say, okay, but I sent an email. That's not an agreement.
Right.
That's an email. That doesn't mean it's a bad thing or you did a bad thing. It simply means we do need to understand that the ruling authority between two parties is going to be the agreement that you signed. You can waive rights that you statutorily have, meaning that the state in the jurisdiction that you live in affords. You can waive federal rights. Now, there are some you cannot, just so you know, so you can't totally be like...
What would be a reason, or what would be an example of something you'd want to waive? Like, would you want to waive anything?
For example, the right to a jury trial.
Oh, okay.
Because it could really just take a long time, and it's costly, takes forever. That's something that's commonly waived.
Yeah.
Sometimes we do, sometimes we don't. Is that a make it or break it kind of deal for somebody who is entering a contract probably only one time for one particular service? Not necessarily.
Yeah.
But for example, this is it, I just remembered the other point I was going to make. It relates to this. So one on the writing thing is, just because it's in writing doesn't mean that it's a contract, okay? But that doesn't mean that it's not helpful. However, I think there's this misconception that, like, okay, well, I have these emails in writing that show this supporting documentation. And you may have had some experience in this recently, right? Where it's like, okay, here's some additional documentation. It's not a contract, but it bolsters my side. Now, I remember when I was graduating law school, the statistic was that 3% of all litigation cases, meaning an actual filed case where two parties have, well, at least one party has written and submitted in court a claim or series of claims for a litigation matter. 3% of those actually go to trial, which means 97%, as of 20 years ago, are all negotiated. So the reason that's relevant, and again, that data might not exactly be representative of today, but it's not going to be far off from there in terms of an overwhelming majority of litigation matters are settled.
Yeah.
The reason that that's relevant is because all of this data that someone is gathering, like I have written emails, I have voicemails, I have, fill in the blank. What you're looking is for somebody to make a determination based on the contract and all supporting documents, all the other evidence. And as I'm sure people listening would know, like sometimes that's an expert who's, taking the stand in a case. We've all watched TV and seen different types of litigation matters, criminal and civil. So if only 3% are actually litigated in court, meaning the two parties have filed, one claimant has made some claims, a respondent has responded to those claims, you go through a series of procedures to then make different motions in court. Usually a defense side is going to file whatever motion to try to get the case out of court. Let's say those fail. Okay, now you didn't waive jury rights, and so now you are selecting a jury, you're preparing a whole case. If that's only 3% of the time, then who else is looking at those emails that you've put in writing? A mediator, an arbitrator, or the attorney on the other side, because you two are now angry at each other for whatever your reasons, however just or unjust they are. And now two sides who have attorneys are trying to assess the likelihood of success for their respective clients. The attorney's job is to protect their client. So it's not necessarily, always this story of this side is bad and this side is good. Although in your circumstance, there's definitely, I think, bits of that going on. But nevertheless, generally speaking, that's not really how it works, right? So back to the story of it's not just. So I have had people ask me, but I have this, they wrote an email. Worse, they said it to me in front of all these people and they heard him say that. Okay. And so pragmatically speaking, what's going to happen is if two parties are not in agreement on the terms of their contract and how they're, how that's unfolding, then most of the time It comes down to how strong is your contract and what evidence do you have that the other side would know, like, hey, this is an open and shut case. It's very rarely an open and shut case.
Yeah.
And even in a situation where it's profoundly unjust,
Yeah.
profoundly opportunistic,
Mm-hmm.
the sad part of the law sometimes
Mm-hmm.
is that side can prevail when the legalese,
Mm-hmm.
as the attorney that you talked about
Yeah.
shared, is on their side.
Yeah, absolutely. That was something that really stuck out at me, and why I think your perspective and the aspect of looking beforehand at so much does prevent a lot. Because the other thing that you were talking about, arbitration, mediation, these are all things that I think for us lay people who are outside the field, you have this common understanding that you don't want to go to trial. You don't want a jury just because of the time, money, expense, all that kind of thing, which is huge.
Huge.
And thinking that mediation means that you're going to come somewhere in the middle. The both side is going to give a little. That's not guaranteed. And that's something I didn't realize before going into mediation, that it doesn't necessarily matter. Because sometimes it depends on who has the most money and who has the least to lose. In my example, it was a big corporation versus me, a small business.
Sole proprietor of it.
Exactly. Yes. And they already knew all my cards.
Yeah.
They already knew that I had no money to fight. And so even though we had so much evidence on our side, there was no poker face on my part.
Yeah.
I'm also not a good poker face in general, but they already knew. And so even though there was so much discovered that was wrong, that could be legally fought, they said essentially, fine, sue us then.
Right. The reality was that they knew the cost of litigation, and they knew they could withstand that.
Yep, they did. And I had great, advice from my attorneys who said, given all that we have, and they listed the series of things, there's a good chance you would win. But we can't guarantee it.
Right.
And it would cost
so much.
At least $100,000. It would be all this time, and it would probably not go to trial for about a year. So, that is something that I didn't anticipate. I thought coming in that, okay, well, yeah, of course I want to avoid this. And of course I don't have the time and expense for jury and, trial, all that kind of thing. But mediation doesn't mean you're going to find in the middle.
No, not at all. Not at all. Mediation is a tactic. Arbitration is a tactic. And I do want to make a point about arbitration. If your agreement has a binding arbitration clause, you need to be very aware of that. Because what that means is a binding arbitration clause is a clause that states that if the parties disagree, we will go to arbitration. And the decision of the arbiter controls. You cannot appeal that. Now, again, the more pragmatic answer is, do you have the time, money, energy, resources, and desire to appeal it? Right? So I think people put a lot of, and I see this myself, like we negotiate heavily arbitration, mediation, litigation, jurisdictions, all of this kind of stuff because we want to minimize costs. But realistically speaking, most clients do not want to, when they do a full cost assessment, and I mean financial cost, energy, which is our highest resource, I believe, no matter how little or much money we have, like that's just the truth, right? When we do a cost analysis, we don't actually end up wanting to legally fight something, which is why, and this is the part I think that is such a common fallacy in the public. We think, well, if it goes bad, I'll get a lawyer. At that point, it's already so expensive and the damage is done. And the cost of what you will assume is so high that it often doesn't make good business sense, right? Whereas the transactional side, we're often seen as the side that's not necessarily, especially to the layperson who doesn't have experience, right? And nor should they or need to. That's just not what they're doing in the world. They don't necessarily see the point. They're like, oh, I'll just, trust my instinct or trust that the other side. Please don't ever trust that the other side has your best interest in even if they meant to, even if they have a pretty even agreement, which sometimes I come across those and I'm like, oh, how refreshing. You just came to the table relatively reasonably. Yeah. That's wonderful. And then on the other side, I've seen completely one-sided agreements where if we didn't have counsel looking at it, I'm not saying I'm so great, but like if somebody's not looking at it, then there's going to be a largely disproportionate agreement that's going to get signed, right? Yeah. So oftentimes a layperson will see the value of a litigator, but not necessarily a transactional attorney, when in reality, it's the actual transaction and how well that's executed that is more affecting their bottom line than the unlikely event of litigation. And you can avoid it often with how strong of a contract you have at the beginning.
Yeah. Oh, that's so good. So it's like prevention is kind of the same. It's same in medicine.
Right. Because if you had in your change plus cost plus agreement, right? If you had in your amendment to your contract that they have a ceiling at 5% or they have then would you really be fighting? Because then we know the number is 5% of the contract value, period. Yeah.
Yeah. I mean, it changes it right then. And I think that also speaks to, there's so many different types of attorneys out there. And I had an attorney that I go to used for just kind of business rent, like, does this contract look good kind of a thing? And who looked at this contract and was like, yeah, that looks like typical. Looks like fine. My question is, when you're looking at any kind of contract, is it best to say, okay, let me not just ask my family contract or lawyer type person. Right. Let me find a specialist who's in this type of law to look over that contract. Is that something you would advise?
I mean, always. Yes, of course. It's like, same thing in the medical field, right? It's not to say you don't have a wonderful understanding of the body, but if I have a random, situation on my foot, that's not exactly your area of expertise. But I'm sure you know more than anybody else, right? And so I get common questions, and I feel like my default broken record first thing always is, just so you know, this is not my area of expertise. I am not providing you legal advice. I am your friend or your fill in the blank, and happy to give you my thoughts, and usually making sure that the person understands, yes, I have some acumen in this particular area because I do this I look at contracts for a living. I am in the realm of law. For example, I was in a women's group yesterday where the topic was family law. I know nothing about family law, certainly not jurisdictional issues between New York and California and the differences. And that was the particular question that was forward. And I was like, and she was like, well, you're a lawyer. What do you think? And I was like, I have no idea. I don't have anything intelligent to add to this, So in terms of a specialist, yes, a general person might look at that, but if they're never representing a client when they're litigating, or for example, I don't always know all the litigation issues, but I know enough to know when I need to hire one because this is outside of my area. So what I would have loved for that attorney to have said to you is like, look, my area of specialty is general. From a general perspective, it's covering the general issues. I don't know enough to know about this subject matter expertise to tell you that there's something else you need to be concerned about. But if you said to me, or if you said to him, my biggest concern is that we stay on budget and that's not that we cannot go over budget. If you say that, to me, when my client says to me, my biggest concern is XYZ, under no circumstances can we do XYZ, you best believe I am reading those sections. I am looking things up if I need to. I am making calls to experts if I need to, because that is what the client cares about. So, in terms of should you reach out to an expert when you can? Absolutely. I would say the the preface is, how important is this to you?
Mm-hmm.
Is this a really big deal? Is this your business? Is this your bread and butter? Or is this like a one-off where you're just sort of, I don't know, helping in a nonprofit and you don't have any personal liability?
The risk might be small.
Right. You need to assess how important is this to you? Is subject matter expertise important to you? I would say, well, how important is it to you when you seek medical advice?
Yeah.
If I have a broken leg, I'm probably going to want an orthopedic surgeon opinion on that.
Yeah.
Right?
Absolutely.
Not that yours isn't incredibly valuable to me, and you would be able to guide me maybe to the right one versus somebody who doesn't know anything about medicine.
Right.
So it's the same idea.
Yeah. Oh, I think that's so helpful. As far as what we talked about so far, any like additional things that you think you want to add that would be important to capstone?
I think the only thing that I've probably already said iterations of it, but the thing that seems really important to mention that we haven't like fully addressed is, if it seems like it could be an issue, if there's just a little question inside of you when you read something and you're like, I don't really understand all these old English words written in strange run-on sentences, but if I'm reading this correctly without commas in the right place, it doesn't seem to make sense. Please don't assume that it does.
Okay.
That's usually where I end up catching. Sometimes I still do it. You know, I've been doing this 20 years. I will ask what I think is kind of a inane question to my client base and say, hey, this section says this, is that a concern? And I don't know if it is. And I can't tell you how often it's like, oh yeah, that's a big problem. We're not okay with that. And this is why. And it's like a whole series of facts that I don't have visibility into. And the same is true of any attorney, whether it's a private attorney working with you, at a law firm, or you're in-house. Like, there's a lot that goes into any particular transaction. I can't have the eyes and ears of a finance person, of a business owner, of a practitioner, of a fill in the blank. I don't know enough. I'm not a subject matter, even though I deal with this all the time. I'm not an expert in soil. That in and of itself, from a real estate perspective, is such a huge thing, where when the experts know, hey, this soil is next to a railroad, or this soil, there used to be an underground storage tank, or that's just very specific real estate examples. But the gist is, if you read something and it doesn't quite seem right to you as the client, as the party in the agreement, or you're helping someone else, you're helping a friend go through a divorce and you're just trying to use your mind to be of service, or your dog sitter, whatever the story is, if you're reading something and it just like creates, I don't know, maybe it's nothing, but please don't ignore that. I think that's also, like, to fully come full circle, that's also the mind and the intuition coming together. And I think we're our most powerful beings when we fuse those two things together.
Perfect summary. Thank you so much.
Thank
I appreciate
you.
our visit, and I always love our time together.
Likewise.
I can't wait to visit again.
Let's do it.